order terminating or modifying a guardianship for a minor or legally incapacitated individual or conservator. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover SCAO Form PC 638A. SCAO stands for State Court Administrative Office, PC for Probate Court. It's Form 638A, and it was revised in July of 2024. It's very important that you use the most up-to-date form, because if you fail to do so, the court may reject it. This form was primarily updated to address a change in Michigan law as it relates to standby guardianships. Let's work our way through the form. In the bottom left corner, it identifies the statutes and court rules that apply to this particular form. And as you can see, there are quite a few statutes and court rules referenced here because this form is very flexible. It can be used in a guardianship, a conservatorship. It can be used for an adult or a minor. Great flexibility for the use of this form, and it's used after the court has already ruled or adjudicated on the motion or petition that was filed before the court. As you can see from the top in blue, that is the identification of the county for the court. Top right is the case number and the judge. In the center square, there are click boxes for the particular usage. If it is for a guardianship for a minor, a guardianship for LII, which stands for legally incapacitated individual, this would be an adult, or conservatorship. This would not be used in a developmental disability guardianship. There is a different set of forms for the use following a court hearing on a DD guardianship. As you can see at the top, there's a space for the court address as well as in the matter of. In the matter of is a space for you to identify the name of the person that's under guardianship or conservatorship. This is not the person that petitioned the court, but rather the person upon which the guardianship and conservatorship is about. Paragraph 1 is for the findings of the court. Notice of hearing was given to or waived by all interested persons. That box is going to be checked, assuming you've complied with the court rule under MCR 5.125 and the related statutes and court rules about notice of hearing on a petition that has been filed at the probate court. Paragraph 2 gives you some flexibility as to whether this is a petition to terminate or modify. Modify meaning changing, terminating meaning ending, whether it's for a guardianship or conservatorship, and whether the court has granted it, denied it, or dismissed it. Paragraph 2B is if the court on its own motion has found that the guardianship or conservatorship should either be modified or terminated, there's a space for that. Paragraph 3 is whether the court has made a finding that the person should be removed and a successor appointed. They should be permitted to reside and a successor appointed. The person may have died who was serving as the guardian, or that the person serving in that role is not performing their duties appropriately, and it's a need for a temporary guardian to be appointed. Paragraph 4 provides for similar options here based on the circumstances of what has been presented before the court. Pretty self-explanatory. Is the person still in need of a guardian or conservator? Is the person a minor who's in need of a guardian? Just some flexibility in the usage of the form. Paragraph 5 provides that there's no qualified person, and therefore a professional guardian or conservator must be appointed. It is a requirement under Michigan law that there be a finding by the court that there is no suitable qualified person to serve in that capacity before the court can appoint a professional person to serve. Paragraph 6 is the reference to a standby guardian that has been designated and that they may no longer be able to serve. Those would be the circumstances upon which paragraph 6 would be used. Paragraph 7 provides that the person with the care and custody of the individual is denying access to a person. One of the big issues that occurs in guardianship and conservatorship matters is there's fighting among family members about access to that person. This paragraph provides a space for a finding by the court in those circumstances. Paragraph 8 identifies if a co-guardian is necessary. And then we've got the order provisions of the court. Paragraph 9, a little bit of repetition from the findings that are above. The petition's granted, denied on the merits, or dismissed or withdrawn. and whether there's a need for a special conservator in those circumstances, as well as in paragraph 11, who is the person that is either resigning or being removed, and whether there is a need for a filing of a final account. On page 2, we continue with again, kind of a flexible document for, depending on the circumstances. This relates to a guardian of an incapacitated individual. Remember, incapacitated individual is an adult. Some spaces for the appointment of the person that's going to be appointed as a successor, and the requirements here. Is there a limitation on the guardianship, on their powers? Is there a temporary guardianship with an expiration date? Or do they have full authority to act? Whether there's a bond that's required. And a very important provision you'll see in that red box right above the line at the bottom, it says the guardian is not permitted to serve until the letters of guardianship are issued. So this is the court order, but you don't have the authority to act until that person is qualified by filing either the acceptance of appointment or designation, as well as whether there's any bonding requirements or any other requirements that the court mandates. So the order does not give you the authority to act. It is after the qualification and the issuance of the letters of guardianship. Paragraph 12b speaks about a guardianship of a minor child, a very similar set of check boxes and options for the court to fill in based on the set of circumstances. And then at the bottom of the document, whether a bond is required or not. And again, similar, it provides that a conservator is not permitted to act until the letters of conservatorship have been issued by the probate court. As we work our way onto the final page, kind of a similar set of circumstances here, that for standby guardianship, you can designate a standby guardianship as described under the statute. And the standby guardianship allows for there to be no longer this gap in time in the event that the current guardian dies, is no longer interested in serving, or resigns, or has health issues. There used to be quite a bit of time in which that person was quite vulnerable. So the standby guardian provision allows for a more seamless transition from the primary guardian to the standby guardian. It also provides in paragraph 14 whether the guardianship or conservatorship is terminated or modified, with some spaces for the court to identify the basis for those modifications or terminations. Paragraph 15 provides if the court has appointed an attorney or guardian ad litem for the individual in relation to the petition that has been filed, whether they are to remain on or whether they're discharged. And then paragraph 16, kind of a catch-all area for additional space for the court to identify other rulings that have been made by the court for the hearing. Paragraph 17 is identifying whether the existing file is now going to be closed or not closed. So the idea is if there's a termination, for example, it may be the end of these proceedings, or if there's continued jurisdiction for the court, you'll keep the matter open. It would be not closed. Space for the judge to sign a date, and then if there's an attorney involved in the matter, a space for the attorney to fill out that space. At the Probate Pro, we are passionate about everything probate. If you've got a question about this order or any probate or trust related issue, visit us at 833 Probate or visit the website at theprobatepro.com.